Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia. It is June the 6th of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. We begin this morning with the judge who oversaw the Parkland shooting trial for that school shooting that happened recently. The judge was noted at the time for hugging the defense lawyers in the aftermath of the case after it was over, went down and hugged the defense. That was kind of weird, and did some other things that seemed to suggest some possible bias. The judge recently, incidentally, decided that they wanted to resign from the bench in part of their term. And this has ultimately culminated in the judge receiving a reprimand in relation to this. So the judge's behavior was so concerning to the bar and the judicial establishment that the judge received an official reprimand. So let's learn a little bit more about what happened in this trial. Let's discuss some of the implications for this case. Let's get started with this. The Florida judge who oversaw the penalty trial of the Parkland school shooter, Nicholas Cruz, should be publicly reprimanded for showing bias towards the prosecution, failing to curtail vitriolic statements. Vitriolic. No, I know this word. Vitriolic. Okay. Sorry. The Florida judge who oversaw the penalty trial of the Parkland shooter, Nicholas Cruz, should be publicly reprimanded for showing bias towards the prosecution, failing to curtail vitriolic statements directed at Cruz's attorneys by the victims' families, and sometimes allowing her emotions to overcome her judgment, according to a state commission. Okay, so Nicholas Cruz was on trial for 17 counts of murder and 17 counts of attempted murder in relation to this school shooting. Somewhat notably, the jury came back non-unanimously on the issue of the penalty, which meant, as operation of law, the judge had no choice but to sentence the person to a non-death penalty result, which in this case, of course, would have been the multiple life sentences served consecutively. And this was so outrageous to some people in Florida that Florida recently passed a bill to allow non-unanimous juries when it comes to the question of the death penalty, which incidentally, there's a US Supreme Court case directly on point that says that it has to be unanimous. So I don't know if Florida's trying to change the law or what, but they passed a law that's directly in defiance of this. So someone somewhere is going to get sentenced to life without the possibility, or someone's going to get sentenced to the death penalty, and the Supreme Court will eventually overturn it. But that's how outrageous people were about the whole thing because of this situation. And now it has been suggested that perhaps the judge may have, from her behavior, influenced the trial in a way that showed favoritism to the defense and antagonism towards the prosecution. The Judicial Qualification Commission found that the circuit judge, Elizabeth Shire, violated several rules that govern judicial conduct during the trial towards Cruz's public defenders. The 6-month trial ended with the Cruz receiving a life sentence for the murder of 14 students and 3 staff members, thus leading to 17 people. After the jury could not unanimously agree in the death sentence, I believe they were 11-1, and I think on one of the counts they were 10-2. So there were multiple different death counts. I think some of them were 10-2, some of them were 11-1, but they couldn't come unanimously back on any of them, and so therefore the operation of law is the multiple concurrent life sentences. The 15-member commission reviewing the judge's behavior found that the judge had unduly chastised the public defender and her team, wrongly accusing Cruz's attorney of threatening her child, the judge's child, and improperly embraced members of the prosecution in the court after the trial's conclusion. This would be the hug that we saw on camera, which, was not a great look because it clearly shows, why didn't you hug the defense's attorney? Because this was probably pretty hard for them too, one would imagine. Probably went through a whole panoply of emotions, but you don't care about them because they represent the bad people, so their feelings don't count, I guess, even though they did their job as they're sworn to do. as public defenders in the state of Florida. You didn't embrace them, you embraced the prosecution team after chastising them publicly and accusing them of threatening your own child and stuff like that, which, showed a little bit of hostility. The commission, which is composed of judges, lawyers, and citizens, acknowledged the worldwide publicity surrounding the case creates stress and tension for all participants. Yeah, but you're a judge and you have to try to adjudicate things in a way that's fair. And you're not supposed to have favoritism. You're not supposed to have any sort of bias. You're not supposed to have prejudice nor favor towards any participant. And here you showed open hostility to the defense and open favoritism to the prosecution. So it kind of failed on that judge job, which might be why you recently resigned, because you realized you weren't cut out for it. So, all right. Regardless, of course, of any emotional issues, the commission said judges are expected to ensure due process, order, decorum, and act with dignity and respect to promote integrity and impartiality of judiciary. Of course, not only impartiality in fact, but also impartiality in perception. Both are important in the judicial canon of ethics. The duty to be fair and be perceived as fair, right? The result must be legitimate and be perceived as legitimate. These are good goals, because if people don't have confidence in the result of the system, they'll be less likely to accept the results of the system. So it's not only important that they come to correct results, but they be perceived as correct, or at least fair, or at least in operation of the law. And when judges don't do this, it leads to problems because, hey, wait a second, it undermines our confidence in the underlying verdict. Maybe that verdict was not correct. In limited instances during a unique and lengthy case, the judge allowed her emotions to overcome her judgment, said the commission, in response to the Florida Supreme Court, which will make the ultimate decision, of course, as the ultimate legal authority in the state of Florida. This is a similar process as well towards the lawyers as well. And every once in a while, you see the Supreme Court of the state defy or go against the recommendation. And incidentally, sometimes they go against it both ways because they are the ultimate authority. So sometimes you'll see the commission or the review board or whatever it is recommend a lower punishment. And sometimes they'll actually institute a higher punishment or the reverse, because it's the Supreme Court and they can kind of do what they want. So you normally expect the Supreme Court to adopt the result. You wouldn't typically expect any other outcome in this situation, because the nature of the violations are probably not egregious enough to warrant more than the public censure. But at least to a lawyer, a public censure is a pretty big deal. Being called out on the record in public and then have that attached to your law license, and you have to report that to other bar associations and stuff. Public reprimand is a pretty big deal for most lawyers. So it would definitely get my attention. Let me just say that. The judge announced last month she would be retiring from the bench effective June the 30th. The commission said the resignation was not part of any deal struck with the judge. The commission report said the judge acknowledged during her testimony that her conduct fell short of what was expected, and her treatment of members of defense teams was at times not patient, dignified, or courteous. Well, she recognizes the truth, and she realizes that perhaps she wasn't really cut out for this. So she resigned halfway through her term, her first term as a judge. So, that's fair enough. Not every job is for every person. She realized that she wasn't for her. So, okay, go back to doing something else maybe. The judge was a former prosecutor appointed to the bench in 2012, and the Cruz case was her first capital murder trial. Broward County system randomly assigned her the case shortly after the shooting, which is also pretty typical. That's normally how cases get assigned in most jurisdictions. It's a random assignment, right? That way you don't get your choice of judge, because we do recognize that judges are human beings and are subject to their own biases, and no judge is perfect. So we try to find the best judges that we can, obviously, the ones who are most able to put aside their personality and most able to just apply the law. But there is a human element to it, and we recognize that. And so one of the ways we try to mitigate for that is through the roll of the dice. So, which judge are you going to get that day? Will it be one that will help you or one that will hurt you? Well, everyone has an equal chance. I mean, for that matter, the same is true of a jury at large, right? We've tried to find jurors who are relatively unbiased when it comes to the case, but we can't put aside their underlying personality. So in some ways, we do the same thing when it comes to juries. It's a little bit of a roll of the dice. You get 12 members of the public and you hope for the best because we don't have any better alternatives because of the human experience. The judge's attorney, because of course, being a smart attorney herself, when she is being sanctioned, she hires an attorney to represent her because of course she does, because she's not an idiot. So the judge's attorney did not immediately return the call or email that sought comment. So she probably saw the writing on the wall. She decided to mitigate her own damages, and well, this is where we are. The public defender also declined to comment in relation to this incident. The handling of the case drew frequent praise from parents and spouses of the victims, who said she treated him with professionalism and kindness, but clashes with the defense's attorneys drew skepticism. So, yeah, she was very kind to the victims. She's very kind to the prosecution team, but not so kind to the defense. So, that's a bit of a problem because innocent till proven guilty, and even where a person pleads guilty, their sentence has to be decided in a fair and objective way. Before the trial, she criticized two reporters from Sun Sentinel newspaper for publishing a sealed educational record they obtained legally. So the newspaper over here obtained a copy of a record which had been sealed, but the newspaper itself obtained the copy through legal means. And she's like, but I sealed it. Well, you might have sealed it for the purposes of your trial. You might have sealed it for the purposes of your hearings, but that doesn't preclude them from getting access to the information through other means. And you're like, why did you look into the information I had sealed? Because we were curious. Yeah. She threatened to tell the paper what it could and couldn't print, but never did. Yeah, that's always a good moment when judges are trying to tell newspapers what they can and can't print. Something about a Pentagon's paper case comes to mind very directly when we have issues like that. Legal experts said such a move would have been unconstitutional. A little bit, yes. A judge telling you in advance what you can and cannot print, it's almost like restraint of a prior nature. I wonder if there's any Supreme Court cases about that. Yeah. The judge also had frequent arguments with the defense. They boiled over for the first time when the defense and the team suddenly rested their case after only calling a small fraction of their witnesses. So, yeah, this was an interesting little moment in the courtroom. The defense, for whatever reason, had initially scheduled a much longer period of calling witnesses, and they only called about half of their witnesses, or maybe it was a little bit less than that. But they only called half of the witnesses they expected to have. And then they're like, so the judge is like, well, who's your next witness? This was a little hearing that, was publicized. Well, who's your next witness? Well, we don't want to say. And the judge is like, well, no, I need to know. Who is your next witness? And so after a little bit of back and forth on this issue, the defense says, we rest at this time. And the judge got really pissed because you didn't tell us. We brought the jury here this morning. You didn't bring it to our attention. Now I have to send the jury home. They've been sitting in the back for 2 hours waiting to hear his testimony, and now I have to send them home with nothing. And they asked the prosecution, are you ready to go? It's like, no, we're not ready to go because we thought there'd be another 3 weeks of defense witnesses. So none of our witnesses are here right now. So she got really, really pissed at the defense for this move, for whatever reason they did. So that was a low moment. The judge called the defense's action the most uncalled for, unprofessional way to try a case, though the defense, of course, has no legal obligation to call its witnesses or announce its plans in advance. It doesn't. It has no obligation to do that. It's part of trial strategy. Now, when the judge asks you a direct question, you have to answer it, but they don't have to otherwise inform the judge. So when they were finally pushed to give a direct answer, they answered the question honestly, which is their only obligation. But the judge was really mad. So why didn't you tell us in advance? My schedule, my precious, precious schedule. Well, the defense had a strategy they didn't bother to tell you about. Not like the prosecution's telling their strategy, by the way, in terms of what witnesses they'll call, or in what order, or what questions they're asked, or what their theory of the case is, or anything else, right? The prosecution has an obligation to turn over evidence. They have an obligation to turn over material in sort of what they'll use to convict you or what can be used to keep you out of jail, right? They have the obligation to give you Brady material. But the prosecution's strategy, not so much. The prosecution's theory of the case, not so much. Witnesses they're going to actually call, and in what order, not so much. So, yeah, that's pretty normal. The defense said, "You're insulting me on the record in front of my client," before the judge told her to stop. The judge then laid into the defense lawyer. "You've been insulting me the entire trial," the judge barked at the defense lawyer, "arguing with me, storming out, coming late intentionally if you don't like my rulings. So quite frankly, this has been long overdue, so please be seated." Not one of the judge's finer moments. By itself, probably not enough. By itself. But in combination with other things that shows disdain for the defense, like it's probably not any one thing. It's probably not this interaction. It's probably not even hugging the lawyers for the prosecution after the fact. It's not any one thing. It's the combination of things that shows a pattern of conduct, that shows a bias. That's the problem. So, yeah. The two then clashed again during Cruz's sentencing hearing over verbal attacks some family members made against the defense team during their courtroom statements. The judge refused to curtail the statements and ejected one of the assistants after she wrongly interpreted one of his comments as a threat against her daughter. Yeah, I would as a judge remind the gallery that the defense lawyers are not the defendant and are not the bad people. So attacking the defense lawyers is not called for. The defendant's the one who did the bad job, the bad thing. The defense lawyers are representing their client. So I understand the defense lawyers being a little peeved that they're getting called out by family members during sentencing hearing. We're supposed to be talking about the defendant. Like, why is he good or why is he bad? What factors in aggravation or what factors in mitigation? Or how has he harmed you? Or what problems has he caused you? The defense team didn't do nothing to you. And the judge didn't do anything to like curtail it, which I would have done. Be like, your comments towards the attorneys are not proper because they're not the ones being sentenced. And also they didn't do anything wrong. So the judge not acting and not interfering with this again by itself, is it enough? Probably not. In combination, it suggests more of a pattern. After sentencing Cruz, who is 24, to life without parole as required, the judge left the bench and then hugged the members of the prosecution and the victim's family. She told the commission she also offered to hug the defense team. Did she, though? Did she offer to hug the defense team? Because I don't remember anything like that happening. But maybe it was just me. I'm not sure what the defense has to say about that, but I don't really remember that moment, but maybe my memory's a little bit faulty. Okay. The action then led the Supreme Court of the state in April to remove her from overseeing post-conviction motions of another defendant who was sentenced for murder. So the Supreme Court of the state is so concerned about this. You're like, yeah, you can't be a judge in this context right now while I figure things out. Not a great sign. One of the prosecutions of the case had also been on the Cruz team. And during the hearing, in a case a few days after the Cruz sentencing, the judge apparently asked the prosecutor how they were holding up. So the prosecution is now involved in another death penalty case, sentencing. And we're like, how are you holding up from the last hearing? Well, again, in isolation, probably not a problem. In combination, suggests maybe some bias. The court said that the actions at least gave the appearance that they couldn't be fair, which, yeah, that is a concern. It's right in the judicial code of ethics. You have to be fair and also perceive to be fair. And when you do things like this that suggest that you are not fair, the failure of perception is in of itself a problem. We need people to have confidence in the judicial system. We need people have to have confidence in the result and the process, which I think they should have confidence in. I think it's something that is worthy of confidence. And when you do shit like this, it naturally undermines people's confidence. So stop doing that, please. That'd be great. Thus, that brings us to the end of the case of the judge who oversaw the Nicholas Cruz trial, who, among other things, hugged the prosecution team in the aftermath of the sentencing and also reprimanded the defense lawyers. and also didn't prevent the gallery from chastising the defense lawyers, who were, of course, doing not their job ethically, constitutionally, and within the bounds of the rules that they were sworn to do. And she didn't make a point of being like, this is a asset of the system. This is the point. When we have a good defense team, it therefore increases our confidence in the result. The defense team pressing the stain gives us increased confidence in the result. The very fact the defense is there to challenge the prosecution and make the prosecution prove their case helps us have confidence in the outcome. So rather than condemning the defense, we should praise the defense. And also, it's constitutionally required. And also, due process. And also, innocent until proven guilty and the rest of it. But she didn't do any of those things. And so she resigned from the bench and now has been publicly reprimanded, which is one hell of a slap in the face. At least that's the way I perceive it. So a lot of mistakes were made along the way. And also, the Supreme Court of the state will ultimately have authority on this for whatever sanction they deal out. But it's not going well through the commission. And that, from the moment, brings us to the end of the discussion of this story. Well, good morning, everyone. I hope you're having a fantastic day. Everything is great over here in Uncivil Law land, and I hope everything is great with you, the uncivilians. We're having a kick-ass day. I hope you're having a kick-ass day. Life is good. And we are here with more stories and more stuff and all the rest of it. I was so tired yesterday. I was so tired because I didn't sleep yesterday. Didn't sleep well the night before. I was so tired I actually had to leave my improv class early. First time I've done that in like the 12 or 14 weeks or whatever it's been. I was so tired and I'm like, I don't want to go to improv class tonight. But I'm like, you know what? I'll power through. So I took a caffeine pill. I went down there 7:00. By 8:15, I was like, nope. It was not happening. I was having trouble literally paying attention. Right? The instructors are giving instruction, and I'm like, what did you say? What are you talking about? And like our other members of our little troop there were getting up and doing things. I'm like, what just happened? Like, I'm basically unable to process any information about what's going on. So I'm like, okay, that's not good. I can't, I literally can't take instruction right now. I don't understand the instruction. I don't understand what my own classmates are doing. I'm too tired. I need to go home. So I went home and then I went to bed and things were great. Oh, push the button. Thank you for reminding me. Yeah. Improv class is normally 2.5 hours long. It's normally from 7 till 9:30. And then we usually go out afterwards for drinks. So I was like, by 8:15, I was like, because I wasn't getting anything out of it because I was so tired. Also, I have a nice smoothie here. Kick ass. All right. What kind of smoothie? Well, it is Fage 5% yogurt. It is 1 yogurt cup of Fage. It is 2 tablespoons butter, 1 tablespoon MCT oil. It is a scoop of casein protein powder, 2 scoops of amazing greens for some nutritional support, 1/2 cup of strawberries, 1/2 cup of mixed berries, 1 coffee scoop of peanut butter powder, and water. Kick ass. Yes, butter to help increase the fat content, to help and change the macros. So yes, 2 tablespoons of butter, 1 tablespoon of MCT. So 3 tablespoons of fat, basically. So yes, the fat, as we've discussed before, the fat is also helpful with digestion of the protein, and also it helps with the overall calorie. Unsalted, of course. Unsalted, of course. All right, let's discuss a news story. Yeah. So pretty good, by the way. Yeah. Excellent. Okay. In YouTube news, YouTube has somewhat surprisingly changed its policy when it comes to misinformation in relation to elections. As we know, YouTube has long had a policy that prohibits people from sharing information that YouTube says is misinformation. YouTube has revised its policy. This comes from directly YouTube's blog. So I thought we would share it directly from the source as we try to discuss this and why they might be doing this. Let's get started with this. So this is okay. So this is entitled An Update to Our Approach to US Election Misinformation. Okay. YouTube says, today we're announcing a new set of updates on YouTube to address and protect our community, providing a home for open discussion and debate during the ongoing election season. So I wonder what their real motivations are here, incidentally. I wonder if their real motivations are they're already thinking ahead towards the next election and they want people to be able to say the next election is stolen, in case it doesn't go their way. So they're opening themselves up. And then, of course, if it does go their way, then, misinformation again. But they need to open up the policy now so it doesn't look quite as timed to elections. That's what I think is going on. I think that they're concerned that their preferred candidate won't win. And they need the ability to have what they would have perceived to be disinformation and misinformation. But now they need to allow it, but they can't do it so close to the election. It's so obvious. So they're doing it now. But if the preferred candidate wins, they'll just change it around again. So I think that's what's happening, but let's read more. Today, we're announcing a new set of updates on YouTube to address and protect our community, providing a home for the open discussion. When we craft our policies, we always keep 2 goals in mind: protecting our community and providing a home for open discussion and debate. I would think your community would be able to handle it themselves when it came to open discussion and debate, being adults and all, but whatever. These goals are sometimes in tension with each other. Yeah. And there's perhaps no area where striking a balance is more complex than political speech. So, political speech, which incidentally, at least as First Amendment law goes, not that YouTube is the government, but if we care, political speech is the very height of First Amendment protection. It is the most protected speech because political speech naturally is speech about, concerning, and more importantly, against the government. So when it comes to speech and government regulations of speech, the courts will look at different categories of speech differently. The very height of speech is the political, because by its nature, it is criticisms of the government. But there's we have a more important goal than that. We have a more important goal than the apex of the First Amendment, protecting our community, whatever the hell that means. The ability to openly debate political ideas, even those that are controversial or based on disproven assumptions, I guess they get to be the arbiter of what is or is not proven, is core to a functional democracy society, especially in the midst of a political election. One wonders why it wasn't core to the functioning of a democratic society before. Why wasn't the ability to debate controversial ideas or Ideas based on disproven assumptions, core yesterday. Why is it only core today? How does that work? How does that work in that field? Interesting. The ability to openly debate political ideas. Okay. We first institute a provision of our elections misinformation policy focused on integrity of past presidential elections in December 2020, once the state's safe harbor date for certification had passed. 2 years, tens of thousands of videos removals, and one election cycle later, we recognized it was time to reevaluate the effects of this policy in today's changing landscape. Are those videos coming back? Since you changed your mind, are those videos coming back? Are the accounts you banned coming back? Does this have any retroactive effect? Can those people petition? How does that work now? In the current environment, we find that while removing this content does curb some misinformation, it could also have the unintended effect of curtailing political speech without meaningfully reducing the risk of violence or other real-world harm. Wow. The risk of violence from speech, because people might be so upset by the speech they might act in inappropriate ways. We're not going to condemn the people who act inappropriately. We're going to condemn the speech that made them mad, because people have the right to their feelings, and it's the thing that made them mad that's the problem, not them being, jerkasses. With that in mind, and with the 2024 campaign well underway, we will stop removing content that advances false claims, so they still say they're false, incidentally, that widespread fraud, errors, or glitches occurred in 2020 and other past U.S. presidential elections. This goes into effect today, Friday, June the 2nd. As with other updates to our policies, we carefully deliberated this change. I'm sure you carefully deliberated the change, and I wonder why you deliberate the change. Maybe you're concerned about what will happen in the 2024 election, and you're already thinking ahead because you're relatively smart, YouTube, and you've thought about this issue. But yes, apparently now you can say that widespread fraud, errors, or glitches occurred in the 2020 election. So apparently that is now A-okay for some reason, even though it wasn't before for some reason. But it's a core to our political democracy, but it wasn't before for some reason. Please don't ask questions. Nothing makes any sense. This specific aspect of our elections misinformation policy represents just one piece of a broad, holistic approach towards supporting elections on YouTube. Here is what isn't changing. We're ensuring that when people come to YouTube looking for news and information about elections, they see content from authoritative sources, prominently in search and recommendations. So we're going to continue making sure that you hear from the mainstream media first. So it's not about what you want or even what the algorithm wants. We are going to pick for you. This is something Susan Wojcicki did in aftermath of the French bombings that happened, and that news story not getting a lot of traction. She said this is something people need to know. And internally, it was like, what, people aren't clicking on it. It's like, no problem, let's override the algorithm. And so that was perhaps the most notable incident in which YouTube made a choice to force certain content to people's homepages, despite what the algorithm would have otherwise picked for them. Made that manual intervention. Of course, they've also made the choice as it relates to certain sources that they deem authoritative. Unclear whether or not Uncivil Law is deemed an authoritative source, which will be promulgated to your homepage. I hope so. I'd like to think I'm relatively authoritative. I know what I'm talking about. We'll see how it goes. How do you apply to become authoritative? For example, following the 2020 election, we found that videos from authoritative sources like news outlets represented the most viewed and most recommended videos on YouTube. Does that have anything to do with the fact that you were already promoting that content and ensuring that the mainstream narrative had all? Also, when you say that following the 2020 election, we found videos from authoritative sources were most viewed, could that be because the non-authoritative sources that were saying the things you didn't want, you banned and you actively prevented? So sure, the authoritative sources were most viewed because it was all that was left. You banned everyone else. Maybe that was the problem. So saying, oh, we found that the authoritative sources were most viewed, therefore that's what people want. somewhat misses the obvious. As our 2020 election panels with relevant context from voting locations to live elections results were currently shown over 4.5 billion times. So all that stuff that we forced upon you through our choice of creating these wonderful panels and alerts and misinformation warnings 4.5 billion times, which we're taking as a good thing, even though we're the ones that forced it upon you. It's not like people wanted to see that stuff 4.5 billion times. It's not like people were clicking on it 4.5 billion times. You were the ones putting it in the front of their faces whether they wanted to or not. But hey, people viewed it 4.5 billion times. What an amazing result. It's almost like we forced them to. All of our election misinformation policies remain in place, including those that disallow content aimed to mislead voters about time, place, or means, or eligibility requirements for voting. So no claiming that, that the Democrats vote on Wednesdays and the Republicans vote on Tuesdays. This year to help lines, the Republicans will vote on Tuesdays, the Democrat vote on Wednesday. It's a really, really old joke. It's a really old joke. But, we're not going to allow that anymore. Can't have that. False claims that could materially discourage voting. I don't know what the hell that means. Including those that disrupt the validity of voting by mail. Mail is the most secure voting and always has been. And content that encourages others to interfere with the democratic process. The rest of our policy continue to apply to everyone on YouTube for all kinds of content, including elections. This also prevents hate speech, harassment, and incitement to violence. Again, whatever the hell that means. So we'll allow the election disinformation, but not the hate speech. Are you sure, YouTube, that you can tell the difference? Because I'm not sure you can tell the difference. We know that citizens take the integrity of democratic processes incredibly seriously, and so do we. We remain vigilant as the election unfolds, as we did in 2020. Yeah, I bet you were pretty vigilant. You were very vigilant, I'm sure. And again in 2022. An election-focused team, including members of our intelligence desk, trust and safety, and product teams, monitoring real-time developments and making adjustments to our strategy as needed. This is basically saying, by the way, in so many words, that if the election doesn't go their way, or the election does go their way, then that misinformation policy is coming back. Because we can make adjustments to our strategy as needed. Like, for example, we won, and then everything becomes misinformation again. We'll have more details to share about our approach towards 2024 election in the months to come. I'm sure we'll learn many more things. I'm sure the detail will be very, very clear. Thus, that brings us to the update directly from YouTube itself on its own blog, which says that election misinformation is A-OK now. So you can say if you want that the election was stolen and there are all kinds of false claims, that's all A-OK. That, that the machines lied or the voting lied or whatever, but don't say mail-in ballots, that mail-in balloting is bad. Don't say that. But you can say other things because debate is core to democracy, and we're just now learning that. But it's only core until we win, in which case it won't be as core anymore. So we'll see. But that is the change to YouTube policy from the horse's own mouth, and that for the moment brings us to the end of discussion of this story. Black tea with lemon plus raspberry lemonade. Baller. Get the little packets. The little packets with the flavor in them. One packet each. Kick ass. Push it. Thank you. Yeah. All right. What else we got going on? All right. What reader app do I use? I believe it is called Reader Mode, readermode.io. I thought it was nice to try to make the pages look more uniform. I thought that would be a good thing. Also, with black, with the white text, I thought would be a little bit less glary. I always look for ways to try to improve things for you guys. So I think this is good. I hope it is. Okay, great. Yeah. So we add a little dark mode in there. Add a little dark mode, make things a little bit less glary on the screen. It's nice. My only concern is that because every story looks the same, that people will think it's the same thing. Despite the thumbnail and titles and everything, that people will think it's the same thing because the layout looks the same. But well, this is what I'm going with for the moment. So yeah. In flood insurance news, the federal government has recently changed the rules in relation to flood insurance, and Florida has joined 9 other states in a federal lawsuit that challenge these regulations. Flood insurance, as I'm sure homeowners know, is almost never offered by private insurance companies. That is because it's offered by the federal government. So, why would they to some degree? Because the federal government will do it for them and take away their risk profile. So, yay. So the federal government offers the flood insurance when private insurances don't. But of course, that leads to problems because who do we insure and how and when? And as we know from a lot of hurricanes, for example, this can be quite expensive. So maybe we should change the rules to perhaps discourage people to build houses in certain floodplains. Well, whatever the rules are, of course, we're going to sue over it as it might relate to current homeowners, new homeowners, value of property, and so forth and so on. So let's learn a little bit more about this. Florida has joined 9 other states in a lawsuit that challenged the overhaul to the National Flood Insurance Program, arguing that the system is flawed and will drive up premiums for many property owners, which maybe it should drive up premiums a little bit because it's been expensive. The lawsuit, which is led by Louisiana, which was filed in Thursday in federal court in Louisiana against the Federal Emergency Management Agency, FEMA. The change came after program changes in 2021 became fully effective April the 1st. The program plays a major role for Florida residents, many of whom are required to have flood insurance because of home mortgages. Yeah, if you live in anywhere that's a floodplain or a hurricane place, I would definitely require you to get flood insurance as well as homeowners insurance because it's my asset, right? I'm the bank. I have a lien on your home from the mortgage. So I want you to protect my asset because it is my insurance against your default. So if the asset disappears, I lose my security. That makes me really sad. So, yes, I would probably require you to have the insurance. That would be a good thing. A document in the lawsuits the program says, no, a document in the lawsuit says the program includes about 1.4 million Florida policies with a total coverage of $360 billion. There's a lot of homes in Florida that are covered by the home insurance. So $360 billion. Louisiana, Florida, and other states are challenging the new rule, which is known as Risk Rating 2.0 Equity in Action, that proposes to change the methodology for determining the price. Among other things, the lawsuit alleges the system improperly considers hypothetical future risks and doesn't properly account for mitigation projects to protect property against flood damage. So, I mean, all future risk is to some degree hypothetical because, of course, it hasn't happened yet. But, we can kind of see trend data and stuff like that. And our risk aversion as a insurance company is growing. And also, how good is that mitigation projects? Also, when we're considering insurance, we typically consider it en masse. So we look to what's kind of true of the community in general rather than individual efforts for the most part. So, but we're not taking enough things into account, we say, federal government, okay. While the agency, FEMA, paints a picture of a nuanced calculation using massive data repositories that reveal a property's individualized risk, the reality is much simpler. Flood insurance is going to be much more expensive for pretty much everyone. Well, maybe, yes. We did all the computer modeling using the computers, crunching a lot of data, looking at trends, and we can't help noticing that these floods and the hurricanes and so forth are costing us a lot of money. So yes, flood insurance might be a lot more expensive, but maybe that's just because it's the price. People want to live in the floodplain, we want to insure against a flood. It's going to be a little bit expensive. So yeah. A section of the lawsuit that focuses on Florida says high insurance rates will cause people to leave the state of Florida because they can no longer afford to live there. Well, at least not in the floodplain part, which, depending on how we calculate that for Florida, could potentially be a lot of the state because Florida is very, very, very flat. So, yeah. In addition, it will depress property values, particularly in areas where flood insurance is required. But FEMA says on its website that it revamped systems that take into account more variables that affect flooding and result in rates that are actually actuarially sound, equitable, easier to understand, and better reflect actual risk. For example, it said the previous system did not account for the cost of rebuilding homes because it only accounted for the materials in the home. So how much is the home worth? Well, it's worth $300,000. Okay, but how much does it cost to actually rebuild the house? Right? Because there's labor involved. The labor is going to cost some money. So we only were insuring the material worth of the house. We didn't account for the labor necessary to rebuild it. So, yeah. Policyholders with lower value homes may have been paying more than their high share of risk, while policyholders with higher value homes may have been paying less than their share of risk, the agency said. Risk rating 2.0 was not just a minor improvement, but a transformational leap forward for the NFIP. Not for nothing, but agencies, I'd really avoid using the phrase leap forward. It doesn't have great historical connotations. So, yeah. The Attorney General signed off on the lawsuit for Florida, along with Louisiana. The other plaintiffs are Idaho, Kentucky, Mississippi, Montana, North Dakota, South Dakota, Texas, Virginia, and other local governments in Louisiana as well. The 146-page lawsuit makes a series of allegations, including they violated the Administrative Procedures Act by making changes that are arbitrary and capricious. The Administrative Procedures Act is your go-to law. If the federal government is doing something, typically it is governed by the APA. It is the thing that applies to most federal agency action that requires, it is the rule for rules. How do you go about establishing rules? That's what the Administrative Procedures Act is. How do you go about, what are the rules for creating rules? And most federal agencies are bound by them. And so it is often used as a mechanism to attack agency action. It's like you didn't follow the rules properly. In this case, by making changes we alleged are arbitrary, which of course the government is allowed to do. They're not allowed to be arbitrary. As part of the argument, pointing to FEMA's consideration of climate change, which it says does not relate to the risk of property today, which climate change is, of course, a long-term concern. But then, of course, these houses are going to be there for a long time. So building in some of that risk now doesn't sound completely irrational, but that's what they're arguing. Equity in action uses a catastrophic modeling, which takes into account hypothetical future events. All future events are hypothetical, including hypothetical events resulting from climate change, the lawsuit says. The agency does not disclose what these hypothetical events are, nor does the agency explain how the hypothetical events change based on hypothetical climate activity. It's a model. It's a model. It's based off past trends, past predictions, a little bit of guessing in the future, a little bit tea leaves. The computer modeling helps a little bit. and sort of some of the stuff. So yeah, but we're really unhappy with the number because it's going to cost us money, right? We like it when the federal government pays attention to the climate, except when it costs us money. So yeah, the lawsuit in part seeks an injunction against the new system and a requirement that federal officials disclose the methodology and data that they used. Okay, so we'll see how that all develops, but I have my doubts on that. Thus, that brings us to the end of the story for the moment about FEMA being challenged on its new insurance program for flooding. They have come up with a revised system that takes into account more things based on computer modeling and also concern about the climate. We're also concerned that states like Florida might be underwater in the future based on current models. So we are wanting to change the price when it comes to insuring the homes, both to account for the cost of rebuilding the homes, because suddenly we realize we forgot to do that, so our bad, and also to account for these things, which are hypothetical, but then again, we are reasonably predicting they're occurring. So we're challenging challenging this under the Administrative Procedures Act. We'll see how that all progresses. And that, for the moment, brings us to the end of discussion of this story. Good morning, everyone. Good morning, Sheila. All right. Push the button. Thank you. Yeah. Okay. In unexpected toppings on my hot dog news, a Sonic employee is charged with a felony after a customer ordered a hot dog and one of the toppings was cocaine. Well, I didn't know that Sonic offered that. My going to Sonic will be much more frequent in the future. I did not realize that cocaine was one of the available toppings for my hot dog, but apparently it is. And we are charging the employee with a felony for the cocaine hot dog. Let's learn more about this. The 54-year-old cook, no. The 54-year-old cook at the Sonic Drive-In in New Mexico was arrested last week after a customer bit into their hot dog and found themselves with about $100 worth of cocaine in their mouth. Wow. That's just convenient, right? I mean, you buy the hot dog, it's served to you, it's got some chili on it, it's got some cheese on it, maybe some mustard, also some cocaine. What a unexpected benefit. The cook was taken into custody and charged with 1 count of felony possession of the cocaine. According to a press release from the police department, the female customer ordered the Coney dog, a hot dog topped with chili and melted cheese from a Sonic restaurant located on South Riverside Drive, about 100 miles northeast of Albuquerque. Police say the customer then found the bag of illegal narcotics in her food and contained authorities. Unclear whether the Sonic is related to what is it called? Hold on. I got to make the joke work. Hold on. Los Polos Hermanos. Okay, great. Thanks. All right. Moving back to the story. All right. No, wrong story. There we go. Unclear whether the Sonic Drive-In is related to Los Polos Hermanos and Madrigal Electromotive Enterprises in the great state of New Mexico. But this apparently is the new distribution chain. But we've gone from small chicken restaurant to major franchise. What a shocker. I did not think Gus Fring would be this sloppy. A field test on the cocaine came positive for 1 gram of cocaine, which the police say was inadvertently placed during the time he was preparing food while at the location. Authorities say the arrest addressed a significant potential threat. And it's like, what is this? What is this new topic in my thing? And how the customer recognized it's cocaine, I suppose, is another story. But yeah, court documents obtained from Albuquerque provide additional information regarding the arrest. According to the probable cause affidavit, first responders arrived at the scene and located an adult female customer who claimed to have found narcotics in their hot dog. You know, you gotta like be laughing about this because the police and EMS have got to be thinking to themselves, this person is out of their mind, right? They're obviously high on drugs, or it's their drugs, or they're delusional, or they're crazy, right? There is no way that EMS is responding to the scene thinking this is real. They are thinking we are being jerked around. We're being called off on another call. Oh, yeah, you found a paper bag full of dog poo on your yard. I'm sure you did, right? But it turns out it actually happened. So I guess good on them for showing up. The woman reportedly told the officers that when she took a bite of the food, she tasted a foreign object. When she spit it out, she found the plastic baggie containing the cocaine. Yeah, okay, but she didn't Karen this by talking to the manager, who I would have been sure would have been happy to comp her meal. She decided to report this to the police. I'm thinking the manager really wishes that she had just talked to them instead. We'll give you a gift card. Will $100 do? It is not immediately clear whether the customer actually ingested any of the cocaine, but I'm sure that'll be a fun report to the hospital. Investigators were able to obtain surveillance footage from inside the restaurant that shed additional light on what was happening. The footage from inside the restaurant allegedly shows the cook making a transaction while another employee was there. They then appear to go back to the job of preparing food. However, soon after the transaction, police reported that the cook stopped what he was doing and began frantically searching the area as if he lost something. Oops. So he's making a little street buy, maybe, from his fellow guy. He's making a little street buy in the middle of the Sonic. And then he goes back to preparing the food, and he accidentally put the cocaine in the food as he was prepping it. Wow. And then he's realized, where's my cocaine? I've lost it. He begins frantically searching around. Per media, police say that the behavior indicated he may have lost the baggie that was found inside the hot dog. In subsequent interview with investigators, police say that the cook admitted that the small baggie contained cocaine and belonged to him, alleging he purchased narcotics from someone in a restaurant parking lot. I tell you what, man, the Gus Fring operation is really letting itself go. This is not the kind of thing of that Las Palmas Hermanas quality that I've come to expect. A supervisor at Sonic reportedly refused to comment on the incident when reached by the news. Yeah, I bet the manager doesn't want to comment on this story. I think it's pretty scary, a customer said. We come here to get food, and if a child had found that, they could be pretty bad or dead. Wow. Thus, that brings us to the end of the tale of our Sonic hero, Jeffrey David Salazar from New Mexico, the great city of Albuquerque, where Bugs Bunny was always trying to go. But Jeffrey found it. He found Albuquerque, and then he found someone willing to give him a little bit of cocaine on the side, a little bit of sniff for the nose, and then he just forgot what he was doing and went back to making that hot dog and slipped it into the hot dog. Customer noticed, called EMS, and wow. So that's all happening. Fun times happening here. Get that Coney hot dog today, man. That 2-for-1 special on Coney hot dogs is not going to last forever, now with cocaine. And that, for the moment, brings us to the end of discussion of this story. All right. Yeah, we could. Do we want to do that story now? I guess we will. Well, let's give it a fun. Let's give it a fun. All right. Push the button. Yeah. Okay. Okay. In I didn't understand the assignment news, the Department of Child Safety is being sued because it placed the children it took from unfit homes into a foster home that ran a abuse ring. So, didn't understand the assignment. Took the kids from dangerous homes, put them into a house that runs a child ring. Fantastic. We'd like to sue them for, doing this. And of course, they're over here with qualified immunity. I had no idea. Was I not supposed to do that? Was that wrong? If anyone had told me I was not supposed to place the children into an abuse ring, I would have done it immediately. Yeah. Let's learn more about this. Let's learn more about this story. The state of Arizona is arguing that it should have qualified immunity from a federal lawsuit seeking it to hold it liable for placing the children who were in further harm's way, by putting them into a foster home that forced them into a salacious abuse ring. Well, this is going really great. Out of the frying pan, into the fire, out of the dangerous home. How about forced child prostitution? Great. Going over really well over here. The individuals are suing the state agencies and officials for placing one of their siblings and themselves into foster care with a former civilian military leader named David Frodsham, who is a noted abuser, who is now serving 17 years for leading the child ring. So, not maybe the best person to oversee the children. In addition to exploiting the children, authorities say the conspiracy put national security at risk by making the individual, who is a military leader, subject to blackmail. So, yeah, maybe some people were exploiting him for information because they knew some deep, dark secrets. The Associated Press found that Arizona and the U.S. Army, for their part, might have had some clues that all was not well, but decided not to look into it too much further. Why would we look into it too much further when we had all these red flags? I like red flags. Red is a nice color. Let's keep going on. Arizona has received 20 complaints of misconduct against the individual and his wife, but even though it had received 20 complaints, it already had 20 complaints in hand against David and his wife. 20 complaints. It still allowed them to serve as foster parents to the individuals who were suing. 20 complaints. 20. They had 20 complaints against them, and we see nothing wrong. Let's continue putting the children with this wonderful, wonderful couple. 20 complaints? 21 is our magic number. We haven't reached the threshold yet. The Arizona has attempted to deflect blame to its contracting agencies, which it says investigated relevant complaints, but deemed them unfounded. Well, I feel real assured there. Someone actually took the time to report 20 instances of misconduct to the government. The government looked into it and says, we see nothing wrong. The individual who is suing, who is now 20 himself, alleges that the foster parent abused him over a period of 12 years. 12 years of abuse of a salacious nature. 12 years it went on with him in the foster care. It only ended when the guy was arrested in 2016. When the guy who was suing was 13 at the time. Because that's how math works, right? So the guy alleges that he was abused from the age of 2. From the age of 2 for 12 years. Great. And the agencies that place the children in the foster care, are they suing them for negligence, emotional distress, assault, and battery? Going super, super well. In November, Trevor moved for partial summary judgment. Arizona argued qualified immunity. We had no idea. We had no idea that should we not have done that? Was that wrong? You can't sue us for putting the 2-year-old with the 20-time accused person. I mean, who could have possibly seen a problem with that? The Grand Canyon State says its caseworkers believe the foster care placements to be in the best interest of the child. Wow. Well, one of two things is true. Either we have the most perverted definition of best interest of the child ever, or we're not very good at determining the best interest of the child. I'll let Arizona pick which of these universes it prefers to be in. And the decision was merely an exercise of professional judgment. Just a minor oopsie doopsies, any professional can make this mistake. There's no reason a caseworker should have qualified immunity, argues the Arizona attorney who represents the people who are, abused since the age of 2. They say that caseworkers are sometimes in a tough spot and may have to make tough professional calls, but I'm not exactly sure that this is one of them. The bad guy's lawyer argues that qualified immunity should be limited to situations in which caseworkers approve or revoke foster licenses and that it's inappropriate. Okay, no, let me redo the line. The lawyer who is suing says that qualified immunity should be limited to situations in which caseworkers approve or revoke foster licenses, and that's inappropriate to shield states from negligently placing a child or failing to investigate a complaint. Yeah. Qualified immunity began as a judge-created nightmare concept that limits legal liability for government actors. Arizona, for its part, codified qualified immunity into statute, which specifically grants immunity for decisions relating to foster care licensing and certification. Dude. What a nightmare. Oh my God. They actually codified into statute. Oh my God. Am I going to actually have to rule for Arizona on this one? Life sucks. The state argues even if it's not entitled to immunity under statute, it's entitled to qualified immunity as a common law defense, and announced the claims is nothing but a vain attempt to remove plaintiffs' claims for qualified immunity protections of the statute. A vain attempt? Wow. I mean, damn. You have no love lost over here, do you? I mean, these little children were taken care of for 12 years. Why are they complaining? Qualified immunity grants government officials immunity unless they can show they were deprived of a right, and more importantly, that the right was clearly established, which anyone who is familiar with this channel knows how difficult that can be. Yeah. The defensive doctrine has frequently faced criticism in all kinds of cases. Supreme Court Justice Thomas has called for complete overhaul as the concepts used to stray afoul of whatever intent it might have had in the first place. Yeah, the sad thing about this is I know, and you know, that the state has a pretty damn good chance of winning. And there's nothing I can do about it. That's how much this goes. Shit. In court documents, Arizona calls the position on immunity bizarre and misguided, and says it amounts to a request the court ignore decades of case law and adopt an unprecedented narrow view, which would render the statute meaningless. Sadly, Arizona's probably not wrong. Great. By contrast, the victims' lawyers argue that benefits of extending immunity are outweighed by risk of subjecting children to potentially devastating and lifelong damages. Accountability is important, says the person who was victimized in the court filings. Counsels for parties did not immediately respond to comment. Thus, that brings us to the end of the case of David Frodsham, and more importantly, the Department of Child Services, who decided to take at-risk children away from whatever homes they had and put them into the child abuse ring. for many, many years, starting at the age of 2, even though there were already 20 complaints. The state argues qualified immunity. The state is probably right. I don't like qualified immunity very much. Whatever point it had, it has long since exceeded. So Arizona, I would bet, is going to win. So a depressing outcome to a depressing story. Sorry for the 12 years of abuse. You have no remedy. Wow, that's great. That, for the moment, brings us to the end of discussion of this story. Push the button. You know it's a bad day. You know it's a bad day when Uncivil Law judge is sitting here thinking like, I'm going to have to rule for Arizona, aren't I? Yeah. It's tough out there sometimes. Tough out there sometimes. Prove me wrong, Supreme Court. Prove me wrong. Please. PGA and Liv have agreed to merge. That should be an interesting antitrust lawsuit, I'm sure. All right. Your buddy murdered his wife. Can you discuss it? Sorry about that. Let's see what else we got today. What else we got today? Let's do this one as a teaser, or do this one as a potential teaser, because I'm interested to see if people would like coverage of the story. All right. Can people petition to remove statutes? You can always ask your legislature to remove a statute. Sure. Of course you can. Yeah. Call your elected representatives. Get involved. And police officer being held for no. Actually, QI is not a statute, but that wasn't the question. The question just asked me if you could remove a statute. I don't. Okay. In Arizona, also, it is a statute that's for 0.2. Yep. Anyways. In police being held accountable for inaction content, a jury is currently in the process of being selected for a school resource deputy in relation to the Parkland shooting. This was the shooting with Nicholas Cruz. The judge recently was reprimanded in relation to this. Well, also in relation to this, there was a deputy who was there at the time, at the scene, and basically stood outside doing nothing. And they're trying to bring criminal charges against him, which makes me hope for the future that we can bring this to Uvalde, because I want to prosecute literally everyone. I'll do it personally. Maybe I need to move to Uvalde. I can move to Uvalde myself. I'll move to Uvalde and I'll run for prosecutor, and then I'll prosecute literally all of them. That would be good. Maybe I should do that with my time. So let me know if you want me to move to Uvalde. I need a lot of money. I'm also going to need a lot of money for my campaign. My campaign is let's prosecute literally everyone. But anyway, someone is living out my dream right now in Parkland. So let's learn a little bit about this and whether or not we can extend this to Texas. The next phase of jury selection is underway in the trial of Scott Peterson, the Broward Sheriff's Office deputy accused of failing to confront a gunman during a school shooting. Peterson, who is now 60, retired with a $100,000 pension after the shooting, is facing 11 charges, 7 counts of felony neglect, 3 counts of misdemeanor culpable negligence, and 1 count of perjury. Very exciting stuff. There was 55 prospective jurors as of Monday afternoon. The jury will be narrowed down to 10, 6 jurors, and 4 alternates. Pretrial publicity was the main topic on Monday. The judge gave potential jurors an open-ended questionnaire asking them what impact they know, learn, or seeing about the shooting. So interesting that we are doing a 10-person jury in this case. This is Florida. Florida doesn't use 12-person juries except in death penalty cases. They typically use only 6-person juries. So I'm curious, yeah, because that's exactly what they're doing here. It's a 6-person jury. So 6 juries with 4 alternates. Yeah, Florida does that. A lot of states use 6-person juries for like misdemeanors, but it's a little bit unusual that Florida uses 6-person juries for felonies. The only time they use 12-person juries is for death penalty. Now, the Supreme Court has said that unanimous juries are required, but they haven't said yet what a minimum number of jurors are. So this is still a bit of an open question, but it hasn't come to the U.S. Supreme Court's attention. So yeah, because this is not a death penalty case, a 6-person jury will decide this case because that's how Florida rolls. Pre-trial publicity was the main topic on Monday. The judge gave potential jurors an open-ended questionnaire asking them about the impact of knowing, learning, or seeing anything about the shooting because, it had a little bit of publicity on it. The judge reminded jurors that having heard about the case wouldn't necessarily disqualify them. That's true. Just because you hear about it doesn't mean you're disqualified. The question is whether or not you have an open mind. Both sides are expected to bring up the idea that the school resource officer is a caregiver, making the case will be watched by legal analysis across the country and potentially setting a precedent, which could potentially extend to Uvalde, for example, because there's no statute of limitations on murder. Now, is there? So this case could be brought by any time by any prosecutor who might move to Uvalde and run for prosecutor and indict literally everybody. Anyways, moving on. Prosecutors accused Peterson of failing, declining, or refusing to investigate the source of the gunshots, seeking real-time information from 5 students who fled the scene, moving towards the son of Gaunscheider, or seeking, confronting, or engaging the shooter. So yeah, failure to act with a duty to act. No qualified immunity for you because qualified immunity is a civil law doctrine and these are criminal charges. So qualified immunity is irrelevant because you're being charged criminally. So yay. So let's see how well you do with the I did nothing for the children as they got shot to death case. Thus, that brings us to the end of the case for the moment of the guy who did nothing in response to Parkland. And I'm curious as to whether the chat thinks this is a case that we should cover on this channel because I am somewhat inclined to try to give it a shot and see whether or not people want to watch this. So I'm thinking that as this actually starts, we might actually watch this, assuming it's being broadcast, which I assume it is because Florida. So maybe we will watch this in real time because it could be really interesting to see how this is exposed and what it might mean for other cases in this domain. So let me know what your thoughts are in the YouTube comments. Let me know if this is something you're interested in. And if we get enough interest and enough people follow it, maybe we'll give it a shot. And it would obviously substitute for our morning streams. We wouldn't be able to do the news roundup anymore because we'd be doing this. So it's a 1-for-1 kind of substitution, but maybe we'll give it a shot. So let me know what you think in the YouTube comments. And at least for a moment, that's the end of discussion of this story. I'm not sure how. Only if I could watch it with an open mind. I always watch it with an open mind. How does this impact Castle Rock? It doesn't. Castle Rock was about civil liability, not criminal. They're going to argue there's a duty imposed by statute, I'm sure. Can I put a poll up in it? Sure, I guess I can. Let's replace the poll. Okay. Should I live stream Parkland trial at the expense of legal news roundup? Question mark. Parkland. Let's see. Officer failure to act trial, I guess, just to make it clear. Let's see what you guys say. Where'd I get my water bottle? Online. Amazon. I bought like 4 of them. I don't know why the Discord thing keeps expiring. It's such a pain in the ass. Such a pain in the ass with Discord with the link. Why can't I just have a fucking permanent link in Discord? Why does the Discord link continuously fail? It pisses me off. Push the button. I create the links with no expiration, no limit. I create a link, no expiration, no limit, and then it expires. What the fuck's up with that? Fucking bullshit. I have an Amazon list, like for purchases. I have a list of stuff that I use on my link tree. I have a list of things that I use for my setup on my link tree. If you want to see what I use for my equipment, in terms of what I want, no, I don't have a list that for that person. They're set for only a week for Discord. No, I set it. I set it manually every goddamn time. Said I want a link that lasts forever because you can do it. You say I want a link. Your link expires in 7 days, but then you go in and say expire never. Maximum number of users never. Generate a new link. Your link will never expire. It says it every fucking time. God damn it. I'll change it in the link tree again. It's the same link. It's the same link. Fucking bullshit. All right, what else we got? Let's do this story and see how this goes. I just want the fucking technology to work. You know, that's what I want in my life. Push the button. Fuck. All right. In federal judge might be too old for the job news, we turn our attention to the Court of Appeals. I know best, the Court of Appeals for the Federal Circuit. The Court of Appeals for the Federal Circuit is a subject matter court. Unlike most courts in the United States that hear cases coming from that region, the Court of Appeals for the Federal Circuit is national. What makes it different is it hears only certain kinds of cases, most notably patent cases is one of the reasons it was invented as well, and also certain claims against the federal government that ask for money. So they do federal claims and they do the patent cases, and that's what they do. They're a federal court of unified national jurisdiction. Well, one of the judges is named Pauline Newman. She's 95, and some of her fellow colleagues think she's a little old to serve on the bench, but she isn't having it. So let's learn a little bit about this controversy at the Court of Appeals for the Federal Circuit. Pauline Newman specializes in dissent. In her 40-year career as a federal judge, she's written 300 dissenting opinions. So when the chief judge for the United States Court of Appeals thought it was time to retire, Newman offered a different view: no. So yeah, every circuit has a chief judge. They're there for administrative reasons to help organize the court and dole out assignments and other things like that. And the chief judge is like, how about retire? He's like, no. And of course, she's a lifetime appointment, so they can't make her. The oldest active federal judge in the nation, because there are some judges that are older, but in retired status, which is a thing you can do. You can retire without resigning. So that makes you a senior judge. And then as a senior judge, you can still hear some cases in a part-time basis, but it allows the slot to become open for other people to use. So she is not retired. She's an active judge. So she's the oldest active judge. She has gone so far as to sue her fellow judges and accuse them of violating the Constitution, which doesn't say anything about mandatory retirement. The colleagues have accused her of misconduct, saying they can no longer do the job she's guaranteed for life. So this is all permeated in a lawsuit that one judge is suing the rest of the court. That's how deep this has gone at this point. So that's all kinds of intrigue over here. So they're like, you need to resign. And they're trying to take things away from her, right? Trying to take assignments away from her, trying to take opinions away from her. Like, we can't force you to resign, but we can try to prevent you from sitting on panels and stuff like that. So she sued them, claiming that she's violated the Constitution because they've effectively ousted her without impeachment. So that's how that's going. It's going great. Newman is working steadily from her light-filled office in Lafayette Square, overlooking the White House and the Washington Monument. I'm not sure I've ever been in her office, but I've definitely been to the Court of Appeals for the Federal Circuit. It's a very nice building. It's a little bit kind of like traditional. It's a little bit like it's kind of old in its style, you know, because it's literally right next to the White House. I mean, it's an easy walk, so it's great. She is surrounded by glass awards and photographs of Supreme Court justices. Her court handles patent cases, and so also some diagrams of inventions, including one of her own. She was an inventor at one point in her life. Newman, who turns 26, says she's not going anywhere. It's important to the nation, if I say so, Newman said. If I really were debilitated, as they say, physically and mentally, I'd hope I have sense to step down. But as it is, I feel I can make a contribution and must. That's what I was appointed to do. It's going fine. Now there's a standoff. The court is no longer assigning Newman new cases. So this is one of the things the chief judge can technically do, right? They normally are just like assigning who sits on what panels to make sure that's even and fairly distributed. And if a judge needs to resign or recuse themselves or is not available for a particular case because maybe they're overseas or they're traveling or something, right? So they're kind of like they're the manager, right? They're just to make sure the work is even. If a person needs time off, if they're teaching classes at a university, something like that, to make sure all those needs are balanced. But we've gone so far as the chief judge is now just removing work entirely. So we're trying to oust her by effect. Newman claims she was also stripped of her assistant, a law clerk, and her office computer. Kimberly Moore, who is the current chief judge, has written staffers chose to leave, and the Newman's failure to understand the situation is a sign of her decline. Wow, we're having old people problems over here at the Court of Appeals for the Federal Circuit for sure. The Federal Circuit is a relatively obscure court, which, you know, it is relatively obscure, all things considered, because it's very subject matter sensitive, right? So it's very, very limited in its role, but very important in my field. And its rulings on patents have impact on the market. But the dispute over Newman's refusal to step down joins one of many debates over how old is too old for a public official to do the job. Federal judges are older than ever, as are presidential candidates vying to nominate them, and also senators who confirm them. Senate Dianne Feinstein is, of course, also facing pressure to resign because that 89-year-old has experienced health problems and cognitive decline as well. Critics say that Newman is an example of unhelpful egoism. She says that she's in a world of rapid technology change and her view is more important than ever, which, fair enough. Newman came of age just as World War II was happening. She learned to fly planes, drive race cars, and ride motorcycles. She became a chemist, and eventually she became a patent attorney, somewhat like me. She helped to create the Federal Circuit in 1982, because it's relatively recent. So yeah, this was something that was created by Congress because they thought they needed a unified system on patents. Before the Court of Appeals for the Federal Circuit, patents were handled by regional circuits. And this, of course, led to circuit splits. And for whatever reason, when it came to inventions, people thought the circuit splits were particularly bad. So the way they solved this problem was by there no longer being circuit splits, because one circuit would hear every single patent case. So there couldn't be a circuit split anymore. So, hey, that's one way to solve the problem, I suppose. So they created the Federal Circuit 1981, 1982 as part of a presidential commission on industrial stagnation, and then was appointed by Ronald Reagan to serve on the court. So she has been there as long as the court has existed. So she's been there a hot minute. There can be no doubt that Judge Newman is a heroine of the patent system, Moore, the chief judge said. The chief judge saying that it's a lesson I've taken to heart is that Judge Newman once told me that her only regret was that she held her tongue, and I think she should never be afraid to say what she's right. I bet Kimberly Moore's regretting that a little bit now. Lol. So perhaps it's not surprising in March when Moore urged Newman to retire or take a lighter senior status, which really is the same thing, by the way. At least if we're using the word retire properly, as opposed to resign. But yes, you can retire and keep senior status. That's an option. Newman, who said that she could not because she was the only person who cared about the patent and innovation system, according to Moore. Wow. Judge Newman thinks she's the only one who cared. I don't know. Some of us care at least a little bit. Perhaps it was a bit of an overstatement, Newman said, but she didn't mind the assertion being memorialized, albeit in a court order accusing her of misconduct. So that's fun. The committee made up of Moore and two other judges subsequently expanded its investigation to include allegations that Newman is refusing to cooperate. Her clerks have also been subpoenaed and deposed, some of them apparently taking the fifth because it's going that well. Moore did not respond to requests for comments, but the court has made public nearly a dozen orders issued by committees formed to investigate Newman's current competence. Those filings allege that Newman has shown significant mental deterioration since suffering a heart attack in 2021. She's still going on strong, ma'am. Newman takes longer than other judges to decide cases, they say, and writes fewer opinions. She could not complete a recent online security training, which I've done those trainings before and they're pointless, but yeah, and blames hackers when she cannot find a file on her own computer, according to the committee. She allegedly forgot a court rule in place for the past 5 years, instead referring to a long-dead chief judge. So she forgot who the chief judge was because, that changes from time to time, and she apparently forgot who it was, which is, not great. She's also accused of mishandling a serious dispute between two of her staffers and threatening to have complaining employees arrested. One is quoted as saying, "I believe Judge Newman is simply losing it mentally." Her own staff are not having a great time. Newman has called the allegations either false or grievously distorted, also calling them disconcerting, she said, coming from colleagues that she's known for many years as straightforward, decent people. Two other active judges on the court are in their 80s. Most have served with Newman for at least a decade. Once again, by the way, I'd just like to kindly remind President Biden and the Senate that I am available. I'm 42. I'm a patent attorney. I can do the patents, if you want, or I can do not patents, Court of Appeals for the Fifth Circuit, or something else would be fine. I remain available. I know things. I can help. She denies that she's ever had a heart attack and says she's not conferring with ghosts of past judges. Her hacking concern, she says, is well-founded, saying the judiciary's administrative arm is constantly warning us about hacking and scams, which, to be true, they do. So yes, I mean, the judiciary has been targeted for hacking and scams, and they're constantly warned about hacking and scams. So her saying we're warned all the time about hacking and scams is kind of true. The judge is being represented by the New Civil Liberties Alliance, which says it's unconstitutional to force a federal judge to share medical records or undergo psychiatric training or take definite leave, which, to be fair, that makes sense. It's like, I've already been confirmed. You can't make me waive my medical privacy. You can't make me undergo psychiatric tests because there's nothing you can do with the information anyway. And you can't also force me to go off cases. So yeah, it's one thing when your colleagues are saying you're being naughty and the public ought to know you're being naughty, and then Congress can do what you wish, said a former clerk who currently works for the organization that's representing her. It's quite another when judges say we're misbehaving, so we're not going to let you be a judge in anything but name. Going great over here in the Federal Circuit. Who knew the Federal Circuit was full of this much drama and intrigue? This could be a great HBO miniseries, I tell you what. Her attorney helps represent for the nonprofit to represent her. He sees the challenge in line with the group's conservative views on government regulations, alongside challenges to COVID mandates, student loan forgiveness, and gun stop bans. Term limits for federal judges might make sense, but it's not the system we have. The lawsuit also argues that Newman is not notably slower or less productive than her colleagues and doesn't write many majority opinions because her specialty is in dissent. So she prefers writing the contrary view to writing the majority view. A 2017 found that Newman dissented in patent cases 290 times in her career, more than 3 times as often as the next closest judge. A woman after my own heart. She prefers the dissent. She prefers to be the contrarian. Well, someone's got to say it, so better for her, I guess. She takes more time because she cares so much, said Janice Mueller, a patent attorney who's known Newman for 30 years, and it says the judge has always been a slower writer. Being a skilled and vociferous dissenter is a very important role to play. I agree, Janice. Also, I liked your book on patent law. It was very good. So, hey, a woman after my own name who is doing fantastic work in this field as well. It's important now, her allies say, as the U.S. Supreme Court has begun weighing in on intellectual property cases more often. Yeah, that's definitely true. The history of the U.S. Supreme Court when it comes to the Court of Appeals for the Federal Circuit is kind of interesting and sort of funny. So when the Court of Appeals for the Federal Circuit was created in 1981, 1982, for quite a long time, I'd say 25 years, the U.S. Supreme Court kind of left the Court of Appeals for the Federal Circuit alone. I don't know what it was. Maybe they didn't understand it. Maybe they didn't get it. Whatever it was. But the Court of Appeals, isn't exactly, the Supreme Court just basically never, ever, ever heard anything from the Court of Appeals for the Federal Circuit for like 25 years. They didn't hear anything from the Court of Appeals for the Federal Circuit. So well up until the middle of the 2000s, 2000 aughts, the Court of Appeals for the Federal Circuit was alone. The Court of Appeals for the Federal Circuit kind of got it into their head that they were the Supreme Court, though, because they were never challenged for so long. And they kind of start thinking they were the Supreme Court. And so, for the last 20 years or so, maybe a little bit less, the U.S. Supreme Court has been whacking the Court of Appeals for the Federal Circuit around. I think just purely out of spite of at this point, just to remind them that we're Supreme Court, you're not Supreme Court, we're Supreme Court. So yes, patent law has definitely been more interesting at the Supreme Court in the last 20 years than before. And also watching the Court of Appeals for the Federal Circuit get its ass handed to it constantly is kind of hilarious. Newman's refusal to quit on anyone else's terms but her own served her early in her career. 3 decades after she marched for the right to vote, 3 decades after her mother marched for the right to vote, Newman decided that she would be a doctor. No medical school would accept her at the time. She went to graduate school at Yale for chemistry. No chemical firm would hire her. This sounds a lot like Sandra Day O'Connor in a lot of ways. Sandra Day O'Connor also somewhat famously had a lot of trouble getting a job out of law school. I think she was number 3 in her law school on graduation, if memory serves. So she graduated 3rd place in her law school, which, pretty damn good. And she couldn't get a job at a law school doing anything. because that's how it was for women at that time. So Newman also had a somewhat similar experience in this domain. She was the only female researcher for the company that eventually did hire her, and her bosses tried to force her into becoming a librarian instead until she threatened to walk out. Good for her. She would later receive her own patent for colorful, dirt-resistant synthetic fabrics that she helped to invent. But after 3 years, she took her savings and bought a ticket to a boat to Paris, where she supported herself by mixing drinks. So, doing the Alexandria Ocasio-Cortez route. I mean, that's one way of doing chemistry. So she really is a cocktail chemist. Very much a cocktail chemist. Yeah. 6 months later, when she was poor, she came back to the United States and found a job I knew no respectable scientist would take. And that was writing patent applications. Wow. That's a harsh criticism of the patent system. No respectable patent scientist would take the job of writing patent applications. I feel judged. I feel seen. Soon after that, she became a patent lawyer. The next time she went to Paris, it was as a science policy specialist for the UN. On her office desk sits a mug from the bar she couldn't enter during the time at New York University Law. It reads, "Good ale, run onions, and no ladies." She's lived a rich life of tenacity, crawling her way to the top. Good for her. U.S. Supreme Court Justice Ruth Bader Ginsburg praised Newman in 2015 for giving courage to young women with intelligence, diligence, devotion to a very difficult area of law. I mean, patent law does have a bit of a reputation with other lawyers. You know, it was, at least at my law school, it was all the lawyers, the patent lawyers, and the tax lawyers, right? And like the three of us don't talk to each other. So yeah, the patent lawyers were definitely off in their own little world, you know, taken to the island of the misfit toys. So, and the U.S. Supreme Court has often commented about how difficult patent law is and stuff like that. So, you know, the patent bar does have a bit of an air of superiority among itself. So that's fair. The U.S. Constitution says federal judges serve for whatever good behavior means, which we've interpreted to mean life. But okay. Some academics argue that judges can be taken off the bench for behaving badly, whatever that would mean, but who would judge it? Under 1980 law, the active judges of a circuit court can agree to punish a judge after a formal investigation when the punishment cannot extend to removal or indefinite suspension. So we can discipline you, but we can't fire you. If another judge deems a colleague disabled, they can be appointed by the president, but the disabled judge still cannot be forced to retire. The vast majority of the time, the law is the shotgun behind the door, says a law professor who specializes in this. Threatened with public embarrassment, judges usually step down. But he said for judges willing to die with their boots on, telling them to retire is like giving them the death penalty. Yeah, we're not doing the closed door thing over here. We're not doing it quietly behind the scenes. We're going to do it loud and messy, man. That's Judge Newman's style. Newman's attorneys argue the Federal Circuit Committee has defied the law by taking her off cases that is too conflicted to handle the investigation itself, which, you know, who will judge the judges? You know, because it is her own circuit who is judging her. So are they all conflicted, and how would that work? That's an interesting case. The committee says it would consider transferring the probe to a different circuit. If Newman undergoes a medical examination, she'll say that she'll undergo the medical examination only if it's transferred. Ha 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 ha, standoff. Moore suggested going to senior status, which is a part-time status available for those over the age of 65. Veterans of the court say that would give the chief judge control over the caseload, which, you know, it would. It gives them part-time status, which, you know, can be nice for some judges. You get paid the same. You get paid the same and you have less work. So, you know, a lot of judges like it. But some judges are like, no, I want to remain active, damn it. You know, I don't want a lesser caseload. I want more caseload. Screw you guys. I'm not going home. Randall Rader, a former chief judge of the Federal Circuit, I've met him before as well, said he's spoken with Newman recently and found her to be the same Polly I knew 10 or 20 years ago, as sharp as ever. The court also has a record of dealing with aging members with great compassion without jeopardy to work, by giving them more assistance, said Rader. Judge Giles Rich, who is basically personally invented patent law. Giles Rich is an interesting guy. He basically invented the patent law. He basically wrote the Patent Act. And he was just like basically he was, I think at the time, if memory serves correctly, he was a clerk for like one of the senators. I forget exactly. Yeah, but he didn't have like a. He wasn't a lobbyist or something like that. He was like basically just an assistant working in some senator's office, and he basically single-handedly wrote the Patent Act, and then he became chief judge of the federal circuit. So because he wrote the goddamn law himself personally. So he's a pretty interesting character. So he served until his death, till 95, and he was, of course, one of the oldest fact judges of the time. Gabe Roth of an organization called Fix the Court, which advocates for a more accountable federal court system, says active members of the federal appeal court should be on the ball 100% of the time. He also compared Newman to Ginsburg, but not favorably. Ouch. There's this idea that permeates the judiciary that only I can do the job. It's hubris. It's really pernicious. Well, I mean, when you've been elevated and elevated and elevated to get the idea that I'm the guy, it's like kind of like, yeah, you've been told you're the guy. It's anti-democratic and monarchical in a way that's not helpful to the ongoing trust. I hate calling out older women being a younger guy, Roth, who's 40, but that's the situation. Yeah, well, that's where we're at. Ginsburg's decision, of course, to stay on past 2016 helped pave the way for the current conservative Supreme Court. So good decision, Ruth Bader Ginsburg. So I approve of that one. Patent politics are hard to parse. Yeah, they don't really go with party lines. That's for damn sure. In one momentous decision in the field of patents, Justice Thomas voted with liberal members against Gorsuch and Roberts. Yeah, they don't certainly lend themselves to traditional right-left divide. That's for fair, sure. Dennis Crouch, a patent attorney and law professor, met him before. Great guy, runs Patent Leo, smart guy. Said his dispute does not seem ideological to him. It's not. He crunched the numbers, and while Newman is the most patent federal judge, Moore is also close behind. So they look to extend patents and create more patents, and that's part of the reason also the Supreme Court's been whacking them around recently. So more than any other judge is concerned about Newman's health, I think it's real, he said. He suggested Moore, a former electrical engineer for the Naval Service Warfare Center, wants to run a type ship. Naval Service Warfare Center is pretty cool. They do some interesting intellectual property work for sure. Some of it's classified, but they're an interesting organization over the Navy with the intellectual property work. The Navy does a surprising amount of intellectual property work. So, yeah. Newman agrees that there's a lot to be said about term limits, but he thinks that would have to take account for increasing life expectancy and new technology that makes it easier to work in old age. I'm defying the laws of probability, at least my DNA, she said. Her parents lived in the 90s. Her sister died too young at 89. Nice. Newman has never married, has no grandchildren, but has many grand clerks. She's excited by the role of new technology in global conflict or the possibility of lawsuits over coronavirus. Hey, I'm excited about those lawsuit possibilities too. Still, if she had known she lived so long, maybe she would retire from the court and tried another career. Would I be a litigator? Would I be an artist? Who knows? But at this stage, I no longer think about what I do in retirement. I want to spend my last 5 years correcting my colleagues' mistakes. A judge after my own heart. A judge after my own heart. I'm going to be cleaning up your mess until I die. Love it. Thus, that brings us to the end of the case of Pauline Newman, a 95-year-old judge who is being whacked around by her colleagues, but she's whacking back, man. She will not leave the bench until she croaks. She's been there for 40 years. She likes to write the dissent. She's a contrarian, and she wants to stay there for 5 more years until she dies so that she can keep correcting everyone else's mistakes because they're idiots. I love this woman. I love this woman so very much. She is a woman after my own heart. She writes dissents, and she's like, all you guys are morons. I'm going to keep trying to tell you you're morons until literally I die. You'll have to take me kicking and screaming off the bench. And she's actually suing her own fellow colleagues at the Court of Appeals for Federal Circuit. You go, Judge Newman, you kick ass. And that, for the moment, brings us to the end of discussion of this story. Push the button. Yeah. What's LNR? You mean the red letters in the thumbnail? What are the rest of the words that go with LN? Okay. All right. Let's do Hitman and then Florida. Judge Newman, if you need a clerk, call me. We'll take them down together. Or I'll represent you, or help represent you and be part of your team in your lawsuit. Either way, I'll be fine. Alan Parker with the gift memberships. Alan Parker, you've been so very good to this channel recently with the gift memberships. Thank you so much once again for your gift memberships. You are helping this channel so very, very much. And it is deeply, wonderfully appreciated. Thank you. Do I have any familiarity with her work? Not as much, because I tend not to read the sense as much. But she's a woman after my own heart. $20 from Karen D, or apologize, $50 from Karen D. Thank you, Karen. I'm in my garden listening to you and laugh out loud when you said, and my slogan will be prosecute them all. Have a good one, Kurt. Thank you. Thank you very much. Yeah, I'm going to indict everybody. Elect me Uvalde prosecutor, and I will literally indict everybody. I'm going to indict every goddamn official, state, federal, local, who was there that day, and let God sort them out. I'm going to indict them all. I'm going to indict them all for so many counts of neglect, child abuse, and any goddamn other thing I can think of. And let them plead their case. Let them plead their case about how they're not guilty. Let them file their motions to dismiss. Whatever. I want to go after everyone. She is also single. That's a fair point. Yeah, that is true. All right. I need a lot of money to run. I mean, I need a shit ton of money to run. Do you guys have like $500,000? That would be helpful. It's not cheap. I thought I had an open mind. I do. Okay. I think there's a prima facie case to be had. Oh well, can't make everyone happy. Pressing on. Okay. In online dating events, a person met someone on Match.com. Unfortunately, they were already taken. Now, why they're on Match.com if they're already taken, a little bit dubious. But we're going to solve this problem by killing their partner. That way we can have them all to ourselves. Match.com leads to hitman.com. I hope you both fall off a cliff and die. Outstanding. Let's learn more about this Match.com love affair. A 47-year-old woman in Tennessee has been arrested for allegedly trying to hire a hitman from the dark web to kill the wife of a man she met on Match.com. Woman goes on Match, finds man. It's a connection. Turns out guy's married, but I really love him. Let's get rid of the wife. How will I do that? Will I convince her to leave? Will I convince him that I'm the better woman? How about I just kill the woman? Save some time. Wow. Federal authorities took Melody Sazar into custody and charged her with count of murder for hire. The murder for hire is illegal. Please don't do that. According to the criminal complaint filed by the federal government, The federal investigation began late April when authorities received information that indicated that an adult woman had been named as a target in a murder for hire plot. We can't help noticing this woman seems to have been targeted. The information, which came from a foreign law enforcement agency, so perhaps one of our Five Eyes partners who is spying on Americans for us and gave us a little tip off. The information who came from foreign law enforcement allegedly shows that messages from a person known as Katri on the dark web, hosted on a site known as Online Killers Market, to solicit the murder of a woman married to the retired Air Force veteran David Wallace. So apparently the place you go to hire the hitman is literally called the Online Killers Market. Well, we're not exactly trying to hide the ball, I suppose, are we? The name of the target is redacted in court documents. The Online Killers Market, which apparently is a scam site, who could have seen that coming, claimed to have 12,000 registered members across the globe and purported to allow users to submit detailed orders for future murders. The person submitting the order then receives a quote from a hitman that can be directly messaged. Outstanding. But it's really a scam. But we found out about it. And so, well, you tried to hire a hitman. They weren't really a hitman. They're a scam artist, but you tried. So, that's good enough for us. Investigators say that Sazar placed an order for the hit on Wallace's wife January the 11th of 2023 in Alabama. The hit needs to seem random or an accident, or plant drugs do not want a long investigation. Nice. All right, we're trying to clear this right out. I'm so sorry your wife died. That's horrible. I'm here for you in your time of need, dear. I'll be the woman for you. Wow. Women are vicious over here. Yikes. Sazar allegedly ordered the murder, including a photo of the target, the location of the office, her car, license plate number, and details about the home, including comments about the dogs the couple shared. Wow. She might be a little bit serious, guys. She's like, here's where she works. Here's her car. Here's the license plate. Here's her home. Here's their dogs. Here's her photo. Wow. They have 3 dogs that bark and jump, but nice dogs, Sazar allegedly wrote, perhaps to reassure the contract killers not to fear the pet. By March, however, the job had not been completed, and messages appeared to indicate that Sazar was going increasingly frustrated. So she wants to Karen this to the manager of the hitman and say, you're not fulfilling my requests, writing, I've waited 2 months and 11 days and the job is not completed. Timeliness and customer service is important in every industry, I suppose. 2 weeks ago, you say it's being worked on and would have it done in a week. The job's still not done. Doesn't need to be assigned to someone else. Will it be done? What's the delay? Will it be done? Wow. This is going really, really, really well over here. We have problems with the timeliness of the hitman. Sazar had allegedly provided initial payment to the hitman in Bitcoin before even placing the order, according to the complaint. Authorities followed the money trail from the Bitcoin transferred and learned that Sazar had purchased the digital currency and transferred funds to potential killers on OKM. Yeah, Bitcoin does leave a trail, right? Because it's all, on the web. It's all like certified from place to place to place. So it leaves a very nice trail, an authenticated trail, every step of the way. So Bitcoin, a little bit less anonymous than you might have thought. So once they figured out the Bitcoin, they traced it back, which, really, really easy because it's all in the log. They figured out how it was initially purchased. And, you're off to the races. Federal authorities traveled to Wallace's home and interviewed his wife, who supposedly named Sazar as a potential person who might want her dead. So apparently the wife is aware of this other woman and also aware that she might have it out for her. So unclear how that marriage is working out, by the way, since your husband apparently is cheating on you. But yeah, I'm somehow aware of the other woman. She said that her husband Sazar had met on Match.com when they both lived in Tennessee to become hiking friends. Oh, that's it. They went on Matching.com to become hiking friends. Okay, let's go with that. However, she said that Sazar became enraged when Wallace informed her that he was engaged to be married and moved to Alabama. Oh, so he was only engaged at the time. So maybe he was reconsidering his options or something. I don't know. I don't know how it works out for their marriage, but I hope it works out for those crazy kids. Wallace's wife told the authorities that after the move, Sazar allegedly showed up uninvited in the home and issued various threats. Well, that would be a clue. Who wants you dead? Do you have any idea who wants you dead? Well, as it turns out, this woman showed up on my house and said, I wish you dead. So it could be her. Yeah. I hope you both fall off a cliff and die, she allegedly told Wallace at the time, according to the criminal complaint. Also around the time, Wallace's wife reported having her car vandalized with a key. She also started receiving unpleasant phone calls from a person utilizing an electronic device to disguise her voice. Holy shit, dude. Things are really intense over here. Holy shit, dude. I think she wants you dead. Wow. Wallace's wife also confirmed that she and her husband use a fitness tracking app called Strava. Authorities say that based on the information provided to the hitman, including exact times and locations of the wife, they believe that Sazar had been tracking the wife through the app. Wow. So they have a fitness app. The fitness app includes GPS. So she knows the exact movements of the wife, when, where, how, and has been transferring that information. If convicted, she faces up to 10 years in federal prison, putting aside whatever state time she's also facing. Holy shit. You know, well, yeah, you did very much try to hire a hitman through interstate commerce. So the feds would definitely like a word with you. Sazar's attorney did not immediately respond to a message or comment. I've been representing citizens accused of crimes for 32 years across the state, and certainly not my first prosecution I've faced, alleging some type of murder for hire scheme, they said in a statement that they provide to the Daily Beast. Our investigations in its infancy, as I was only retained last week. Good. As such, I find it premature to comment on the facts of this case until such time as each of the allegations have been vetted and such future responses are in accordance with our state rule restricting public comments during pending prosecutions. Yeah, I'm sure your investigation's gonna really work out really well for you. I'm sure you'll figure out it was really someone else behind it all. Uh-huh. Good luck with that criminal defense. That sounds like it's going great. Thus, that brings us to the end of 47-year-old Melody Sazar, pictured here in her hiking attire. She seems like a lovely woman with a bright, inviting smile, but she really, really, really wants the man who at the time was engaged to someone else. And she is willing to kill for it. And the feds found out, and yeah. So things are going super, super great for her. And the feds would like a word with her, and also possibly the state of Tennessee, I would imagine, might like a word with her for the whole murder for hire thing. So yeah, and also possibly Alabama, depending on what happened exactly where. So her feds getting her for this is not necessarily the end of the road. Tennessee, potentially Alabama, potentially who knows where else might also want to have words with her. But that for the moment brings to the end of discussion of this case. Push the button. Yeah. Okay. Some good boys never did you harm. Good boy, never meaning harm. That's all you saw. Been in trouble with the law since the day they were born. All right. I'm not a fan of boiled peanuts. I'm not a fan of boiled peanuts. I never really liked boiled peanuts. I like roasted peanuts, but not boiled. So yeah. All right. In Florida, man meets Dukes. No. In Florida, man meets Dukes of Hazards news. A car went airborne off a tow truck ramp in Georgia as Florida man attempts to escape the scene of the crime. Let's learn a little bit more about this daring escape attempt. In this image, which was taken from police body camera video provided by the County Sheriff's Office of Georgia, a vehicle is seen going airborne after driving up the ramp of a flatboat truck on the Georgia highway. Wow, we really got a really nice shot of this thing on our body camera, didn't we, man? Look at this thing. It is just right in the middle of the airborne spree, looking to get free, trying to escape. Just a good old boy, never doing no harm. Been in trouble with the law since the day they were born, baby. Woo, let's get that going, man. The Nissan Altima stand-in for the General Lee was launched 120 feet, which is 37 meters, down the highway, according to the police report. The driver, who is a 21-year-old woman from Florida, was taken to the South Georgia Medical Center with serious injuries in relation to this incident. The incident happened May 24th in Lowndes County, according to body cam footage. The county sheriff's deputy was responding to a car accident on the opposite side of the highway. While the deputy was at the crash scene, his body camera recorded the car drive up the back of the ramp before taking flight for 120 feet, flipping and rolling over in the process, according to the media. The deputy immediately sprinted over to the crashed car, where he found the driver, the 21-year-old Florida woman, suffering from serious injury. Transferred her to the medical center for further medical care. No condition on the driver's condition has been made public. See full video below. Oh, dude, you know what we have to do now. Oh, there's no way, guys. Hold on. Hold on. Just a good old boy, never doing no harm. Still in trouble with one. Take it easy. Take it easy. Crazy.
Good. At their last 1050 rollover. Last and second EMS immediate roll. Previous 1050, 84 west.
Okay, hold on. We hold on. Yeah, okay, hold on. Born free, free as the wind blows, free as the grass grows. Thus, that brings us to the end of the story of Florida woman who did their best Dukes of Hazzard impression, but apparently the Nissan Altima is not built as ruggedly as the General Lee. The General Lee used to do this kind of thing all the time and be absolutely no worse for wear. Nissan Altima, not in the best condition, it seems. So all that stuff is happening here in Florida and Georgia. And that, for the moment, brings us to the end of discussion of this story. Well, I mean, she did survive the crash. So, I mean, the Nissan Altima might not be a bad choice. I mean, she did survive the crash after jumping at 120 feet, rolling over and everything. She did survive. So the Nissan Altima might be the right car for you. I'm just saying. You know, oh yeah, we're definitely, so the full video is definitely getting put in, and then I'm putting the part where I sing it in slow motion as well, because I absolutely can. Yeah. I'm in good spirits now. The poll results. Good question. 84% of you say yes, I should live stream it with 162 votes. So I will definitely fold that into consideration. Thank you very much. Super chats that came in today. Z Seltzer gave a $2 super chat. Admiral Nelson gave $2. Sandra Ramirez gave 10 gift memberships. Alan Parker gave 20 gift memberships. Thank you so much, Alan, as always. And Karen D with a $50 super chat. All that is extensively appreciated as always. Thank you. That is just the fact that the camera got that camera footage, the fact that he got that on camera is just so cool. It's the coolest thing I ever seen in my life. Now, legend in this department, you got to see this. Yeah. All right, I'm going to sign off for now. I'm going to try to resist the temptation to eat like crazy and stick to relatively healthy food. And then I need to go to the gym at some point to make up for yesterday, and we'll go from there. And we'll see about the thing. So we'll see how it goes. All right, I will talk to you all later. I hope you all have a nice day. And for now, my friends, cheers and goodbye.